Juan Ignacio Ruiz Peris, Carmen Estevan de Quesada, Julia Suderow Rodriguez. Very well welcome to Digital Markets Research Hub. We have in Valencia regular meetings of people specialized in competition law and mainly, but not only, looking at the issues, rising issues of private enforcement, hybrid enforcement, all types of private enforcement. And you have established this very impactful group some time ago. And recently you have hosted the fourth meeting. Very productive, very engaged event, 2-day event with many speakers, and a lot was going on in at this conference. So I'm very grateful for the opportunity to ask you to elaborate a little bit on the event itself, on the main topics which have been raised there. Why wouldn't we start with you, Juan Ignacio, just to provide us the general overview?
Okay, thank you, Oles. Thank you very much. So the event is part of a research project in which we have conducted two previous events in the field of competition and digital markets. The first one was dedicated to lawful cooperation, focusing on digital platforms as hubs of networks. And the second one on issues related to mergers and abuse of dominance or dependence.
This is a regular meeting, and this was the fourth one, as you mentioned. And yeah, I think we have managed to gather a very, relevant group of academics, and the discussions were very, very interesting, very, very insightful. Was a bit complicated because it took place shortly after those terrible floods, but we managed to put it together, and we are pretty happy with the results. So yeah, I hope everybody's going to enjoy the book when it comes out.
Thank you so much. It's always a great honor to be in Valencia, and it's always great. The insightful discussions that we have, they are very open. And Juan Ignacio and Carmen are always able to put a very interesting group of people together from the public enforcement, from the private enforcement, from the academia, and from several jurisdictions. And this is particularly nice because then the event has a very nice size. This means we are not too many people and not too small amount of people, and this opens the debate, and this is nice. And this is a big difference to other events and conferences where it is very difficult to engage also with the speakers. And in the case of Valencia, it's always very nice. And afterwards, the papers that come out, the publications carried out by the project are also very helpful, not only for practitioners and antitrust nerds, so to say, like maybe myself. It's also very helpful for practitioners, for judges very often, which is also great. And this has a great impact at least in places like Spain, where we are able to disseminate in a very fast manner lots of information and lots of learnings about antitrust, putting Spain in a quite active place in Europe nowadays, particularly in the area of private enforcement.
Great. So let us remove to the topic itself, because the private enforcement in different forms is booming. So much is going on. Perhaps it would be helpful for us to figure out what are the types, maybe to provide some taxonomy or some classification about different types of private enforcement. Maybe Carmen, we can start with you, or and then followed by Julia, and then Juan Ignacio.
Yeah, of course. Well, it is true that there's obviously a boom in private enforcement in the last years, a growth in the number of claims, in the value. I would say not so much maybe in the success in all areas, right? And across different sectors, in different jurisdictions, although there is many, some jurisdictions that are clearly leading the path. As for the taxonomy, I would say that obviously there is a very relevant distinction between individual and collective. It is maybe the most important distinction in economic terms, and also from the procedural perspective, also depending on how effective is the collective proceedings in each jurisdiction, because that has also an impact on how the situation is developing at each national level, I would say. That obviously connects a bit with these traditional B2B, B2C divide, since obviously economic individual actions don't make sense for B2C and maybe only for some B2B cases. And we also had a discussion in the conference about whether we should talk about a distinction more in digital markets, particularly more focused on the professional claims, professional users on the one side and end users on the other side, more than B2B and B2C, right? Because that might be an interesting optic to see private enforcement in digital markets. That being relevant, I think we cannot lose sight of that B2C aspect, since in procedural terms, the presence of consumers and the different procedural paths that may be available in the different jurisdictions, depending on whether actions are so B2B or consumer based, is also relevant. So there is a taxonomy that overlaps a bit, and we can maybe discuss a bit later, but I think it's interesting. And obviously in collective enforcement, I would say that the opt-in, opt-out divide is also very relevant, right? For obvious reasons, like opt-out claims being more significant in the amount of damages and, you know, the amount of claimants. In fact, in the last years, as far as I know, there has been a raise in opt-out, especially in jurisdictions like the Netherlands and stuff. So I think that is important, as well as another very relevant distinction, I would say, it's, well, there's third-party funding, because obviously collective actions are not viable without that kind of funding, right? So yeah, that I would say that is more or less the panorama we've been looking at in this conference, right?
Many thanks, Carmen. Julia?
Thank you so much. I would like to add on top of that you can also distinguish between standalone, obviously, and follow-on, which is there are some jurisdictions like Spain that is still stick to follow-on claims, okay, in most of the cases, even 101 and 102. But there are places, particularly places where you have opt-out, where we are moving towards a more standalone system, and particularly based in cases of 102 cases. And related to what Carmen has said about end users and users, you can see that in places where you have professionals and consumers, okay, being able to file opt-out claims, like in the UK or in Portugal, you will find both types of claims, or in the US, whereas in places where you only have opt-out for consumers, you will only have claims of the end users. Although the problem and the conduct is exactly the same everywhere. So we're trying, so procedural aspects are playing a very important role on the way that we are enforcing our material rules of antitrust. And I think that this is a very important thing that really affects even the principle of effectiveness, where you can see that in places where you have a more proactive approach in the procedural aspects and a more developed system, in this type of places, you will find all types of actions that are linked to the different chains or the different points of the value chain, whereas in other places, this doesn't take place or will never take place. And we can also see, and this is quite novel, at least for Spain, that we start to see consumer actions. No, and this is quite relevant. We see in Spain individual consumer actions related to a cartel, and this is the case of the car cartel, whereas in places like Portugal and in the Netherlands, you see consumer actions filed as an opt-out system, even in digital markets, which is also the case in the UK, where you have both. And you will have in the UK, you are more advanced on that. You already have this conflict, so to say, in the value chain. Now, where you may have a problem, what has happened here, we will have other types of issues related to where is the harm? Is it here? Is it there? No, is it a pass on also in the area of abuse of dominance? How does it take place, or is it a different type of problem? So we are seeing all this. It plays also a very important role on how we organize the taxonomy and try to extract some type of knowledge and experience to make things better in other cases. I think this is what I can add right now. And well, another point, which is also important related to the system, you may have very big claims when it comes to the amounts, particularly if you have companies. Okay, just look into the example, digital markets in the UK. Okay, but when it comes to the individual harm, particularly in the case of consumers, this is a very, very small amount. And this is also plays a very important role, because there you have a problem linked to opt-out and opt-in. Because if you have to bring a consumer to court to say, well, you have a problem because a digital platform is abusing of its power and they extract in each year of the €9 that you pay for the X service, okay, €1 is too much. Even if you explain them that they have been paying this for the last 15 years, which can be by now the average time that we have been using a smartphone, or even for the future, we are talking of 15 or maybe €20, and trying to convince a person that has suffered this harm to go to court for this, it's nearly impossible. This makes opt-in completely difficult in practice, at least for consumers.
And I have in the pipeline some questions related to pros and cons and quantification of damages. We will revert to
I won't
this
say something about,
honest,
I won't say something about this question, okay? So I have a vision of an asymmetric growth of damage compensation actions in Europe, both from the perspective of the limited type of infringements concerned and the number of actions brought in each country. Also with regard to the different kinds of action that are brought. The different kinds of actions are brought in each country are very, 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 very different, as Julia says. In any case, the volume of damages claimed remains low in relation to the total volume of claimable damages. I believe that we are facing a new scenario of reduced public enforcement in the United States and pressure, probably pressure on the European Commission, the CMA, and the Bundeskartellamt to moderate their action in competition markets, particularly in the area of digital markets. In this context, the relevance of private enforcement to achieve an acceptable level of deterrence seems clear. Unfortunately, many of these actions will have to stand alone if the authorities give into the foreseeable pressure that I have indicated above.
Let me then, based on this, ask you the following. We remember the narrative, dominating narrative 20, 30 years ago, that Europe barely has any private, except a couple of jurisdictions, that most of the competition enforcement is public enforcement. Now the situation is rapidly changing. And we hear also voices from people saying, are asking, is it a sustainable growth? Isn't it a growth on steroids, so to say? Isn't that we have already some law firms where people specialize exclusively on a specific case, on the follow or damages action specific? Is it a normal evolution of competition system in European member states and in Europe more generally? Or there are some side effects to it? How do you reflect on this kind of evaluation of, obviously it depends on which party you represent to some extent, but as a thinkers, what are your views? Maybe Carmen, again, we start with you.
Okay, well, my view is that there is still room for private enforcement, quite obviously. I mean, it is a bit, don't want to qualify that, but strange to me to argue that, you know, there is too much private enforcement when there are significant infringements that are either not tackled or tackled too late, or that not punished with a sufficient deterrent effect, right? And that has become pretty obvious, I would say, in the last years in public enforcement of competition law. Well, that was pretty obvious in 102 and DMA as a consequence, so to say, right? And in that context that Juan Ignacio has pointed out, I completely agree that we are facing that risk that public enforcement may even be a bit weaker in the next years. We don't know, but that's a risk, a scenario risk. I think that private enforcement has a very important role to play. Not only as in the compensation side, which is the natural side, so to say, but also on the deterrence side, which has always been a very important part of private enforcement in antitrust. So I don't really share that view that there is too much private enforcement, or that, you know, there might be a risk of chaos or fragmentation or all those things. I think we are very, very far from that scenario. There's a room to grow. And I think there's also a market for that, if we want to put it on those terms. I mean, litigation funding is, you know, coming to Europe. There's a, you know, a pretty clear scenario that this is going to boost a bit further. So yeah, that is my view.
Many thanks, Carmen. Julian?
I think let the market decide, no? This is about competition law. So I actually think that our courts are mature enough to deal with all these type of cases and all types of claims that may be filed or not, that the market will and can decide, and that public enforcement takes too much time. If I look into the timeline of Google Shopping, I can only start thinking that this is takes too much time, and that the results are very limited at the end of the day. And that we have seen in several, particularly in digital markets, that once we have a kind of solution or answer, I won't say remedy, the technology is already overpassed by a new technology. And at the end of the day, already in the 60s, the German Supreme Court said that you can't leave the application of competition law to the monopoly of the public authorities. I'm quoting the German Supreme Court, the BGH, and this is from 67, I think. And I do think that there has been always a lot of private enforcement, more or less, known or not, okay? Now we have more damages actions. And this is a fact. We have more damages actions, and they have an impact on deterrence once you have a result. But if I look into the biggest wave of damages actions that we have had right now in Europe, which is the trucks cartel, and we see about the evolution of these cases Europe-wide. This was a decision of the year 2011, okay, a cartel that started in 96. 2024, I think the last decision got final against one of the companies. So we have already lots of years, and at least in Spain, people are now obtaining a compensation, a small compensation, 5% of the price of the truck, according to judicial estimation. In many places, it will still take 3 or 4 years more. Okay, and we will see if they finally get some interest on top of that. So at the end of the day, if I look into this, we make a lot of noise in the area of private enforcement, but the result is still very limited if I compare it to the potential claimable amount, as Juan Ignacio has said, and the potential harm that all these conducts have caused over all these decades.
Many thanks, Julia. Can I just a quick follow-up question? Because Carmen mentioned it at the very beginning that it's very visible, but the success is rather limited yet. So we are still in the pipeline of many. So can you just visualize a little bit the situations, because you are dealing with these issues and you know the substance of them. Where are we in terms of how many decisions have been already delivered by different courts in Spain approximately, and how many of final decisions out of those overall decisions, how many claims have been submitted, so that we have kind of more a clear understanding rather than abstract conversation?
Okay, this can be very confusing, like all statistics, okay? In the case of trucks, we already have thousands of final judgments and thousands of cassation appeals before the Supreme Court discussing exactly the same topic. But when it comes to the total amount of the harm that is being discussed in Spain before the courts, it's very little. We may be talking of 300 or 400 million euros altogether, or 500 million euros, maybe up to 1,000. This is one claim before the CAT. One of the 30, how many claims do you have right now at the CAT? So it's a very small, it's a very small amount. If I compare it Europe-wide, it's a ridiculous amount because the big claims, they are still taking place in the UK, in the Netherlands, in Germany, so on and so forth. And in all these places, apart from the UK and the 5% of the cut in the case of, I think it was Royal Mail, we are still waiting. So this is just an example. And if I look into Merrick's, okay, you also know the case from the cut, I don't know, maybe 10 years of litigation, a huge claim of, I don't know how many billion, 1 or 2 billion, no, if I'm not wrong. And now they are discussing of a settlement of 200 million or something like that. I'm not very sure. I'm talking right now out of the scratch, and maybe we can deliver afterwards the exact date, the exact numbers. But this is what I can say for trucks. In the area of consumers, we have now a very interesting case, which is the car cartel in Spain. It affects 9 million cars that were sold between the year 2006 until 2013. And this is a number established by the competition authority and confirmed also in the final decision, well, the final judgment of the Spanish Supreme Court of the year 2021, 9 million. And we may have before the courts around 30 up to 50,000 claims, which is still a very small chunk of the potential case. And all the courts are collapsed, and all the defendants are saying this is a huge tsunami of claims, okay? And we are talking of claims of an average amount of 1,000 euros per claim. So you can do the numbers.
Yeah, thank you very much. Thank you much. Juan Ignacio, please reflect on
Okay, I agree with Carmen and Julia, absolutely, absolutely in her analysis. I would only point two questions, to add two questions to the discussion. In relation with the reduced volume of damages claimed, that is true, but there is some legal pro in this question. The procedural system in Spain is very short. That makes that we have arrived to have a consolidated doctrine of the Supreme Court about many questions that are probably questions that will guide the decisions of the other judicial courts in other European countries. So in this way, the Spanish jurisprudence is some field of proofs, okay, where many of the questions that will be placed in next years in other jurisdictions has yet a solution. That is positive for all, okay? And a second question that I want point also. You ask about the specialization, the number of the advocates or legal members of the studies that work specialized in this field. Well, this is a business question, okay? This is a business question. This is not a legal question, okay? But in any case, okay, the application of artificial intelligence to legal tech is likely to reduce the number of future jobs and management costs, which will make it more affordable for smaller firms to combine with the financial support of litigation funds to bring new actions and reduce the amount of improper profits left in the hands of the infringers. So I think it really is not important how many people are now working. I think, as Julia says, that Carmen says that there is place for many more. Okay, but I think also that the cost of management of the claims in future will be increasingly reduced. Okay, so that means that will recalibrate in some form. Okay, the litigation scenario. Okay, this is the second question that I want to point. Okay.
Many thanks. Obviously, probably it is a little bit too early for us to say that the system is crystallizing quickly, because it's evolving so rapidly that it's hard to see where it will, how much it will change in the following years. But maybe just your forecast, or your prediction, or your reflection upon the future development of the system in terms of the relationship between the European the enforcement of competition law by the Commission and the follow-on actions in different member states. Do we see some clusters in some jurisdictions which look similar, or they are too embedded into procedural specificity of each EU member states, and it's hard to say that we will have maybe some groups of member states which apply similar thing? Is it necessary? Is it important element of maturing private enforcement of Europe, or in the European Union? Or it will be purely jurisdiction specific? How do you see the evolution?
I see a mixed evolution in which the European countries will learn from the United Kingdom experience and also from the Spanish experience, okay, and will create systems that will facilitate a possible harmonization, more extended harmonization in next decade. Okay, I think this is not a question of today or tomorrow or in 2 or 3 years, but it will be a natural process that which happens in each jurisdiction. Now the differences are very big. Okay, the difference of, if you see Germany, if you see Portugal, if you see Netherlands, if you see Spain, United Kingdom, that is outside, but it's Europe at least. If you see Italy, or if you see all the Balkanic or Baltic countries in which there is no action at all. Okay, no action at all. Okay, so the scenario is too different. Austria is also an example. So it's very different. But I think in 10 years, we can arrive more and more to learn one to the others, and to arrive to a minimum level of harmonization. But you should think always that procedural questions are national questions in relation with the European Union treaties. So that means this is a question that should be voluntarily harmonized by the countries, okay, but cannot be imposed. That doesn't mean that we can use reinforced cooperation for that, to do that, okay, and we can in future say, well, perhaps not all we are agree about to arrive to a more harmonized situation, but perhaps a group of them, that a significant group of the countries, yes. Well, what is relevant, absolutely relevant, I think is the ground of this kind of decisions are two questions. One, as Carmen says before, opt out. As I said in the meeting, okay, at least opt out. Opt out, opt out, opt out. Opt out is the only solution to arrive at an effective compensation of the damage. And second, left to think in the individual form of compensation of damage, and think in a collective way of compensation of damages. Compensation of damages has been always something individual for the judges, something individual for all, something individual for insurance, something individual for all kinds. But in the case of cartels and in the case of competition infractions, it's not an individual damage; it's a collective damage. Okay, and it should be balanced. Which part of the benefits remain in the hands of the infractor, and which kind of the benefits are compensated, the damages are compensated. Okay. And if we maintain the dialectic of individual analysis of the damages in competition law, we are wrong.
Many thanks indeed. Carmen?
I think that there is still, I would say procedural issues are very relevant here. And I don't see, at a short term, I don't see that convergence. The transposition of the RAD, for instance, is not so homogeneous in certain issues that are very significant. For instance, in Spain, we were discussing, in Spain, we've dropped the transposition that was, ongoing. We are going to start again because there was, a lot of discussions, underlying discussions. And one of those discussions was opt-in, opt-out. So if we have such essential questions that are different in the different jurisdictions, I think the scenario at a short term is going to be pretty national based. That doesn't mean that we can go that path forward. And I think maybe long term we will go on that way, but I'm not as optimistic as yet, right? As I think at the moment the scenario is pretty much national based, and we can see that there are 4 or 5 countries that are leading the way. In the other countries, for instance, Spain is a paradigmatic example, I would say. There's a lot of litigation here, as Julia has described. But, we have either B2B individual claims or even B2C, but we don't have the procedural tools to put together strong collective claims. And that is, I would say, hindering private enforcement. Maybe not as the numbers, but as the final result. And a collateral problem is that this is becoming a huge problem for judiciary here, right? As Julia was saying, tribunals are collapsed, and that makes also unpopular those claims, right? So I do think with some time, I think we have to move forward to a stronger collective enforcement, right? So private enforcement from the collective point of view. And another question, and that is maybe more for digital markets, it's not so specific for antitrust. I fully agree with what Ignacio was saying. In digital markets, we may have infringement related to antitrust. That's like the classical thing. But we've seen, for instance, data protection issues that are becoming more and more popular. And I think last report was saying that something like 30% of the claims were already data privacy connected claims in Europe, right? And there we have other types of harms, right? So damages are going to be, will have to be assessed with other concepts in mind, right? We are very bound by, those antitrust ideas that, actual loss of profit, interest, or material harm, right? But maybe in other claims that will be different, right? And that is also something about we've got to move forward. Something is already happening in privacy, in data privacy, but if we are facing other types of claims, I don't know, environmental claims, then we'll have to face other types of issues. And I think there's a lot of room for thinking in the academia. Also, legislators will have to deal with those issues, right? And so it's a very exciting moment. And I think we'll still have to move a lot, right? We are a bit behind yet, I would say.
Many thanks. Julia?
I would like to add to what Juan, Ignacio, and Carmen have said. Let's go back to the example of trucks. Okay, we have judicial estimation. I know each country has a different solution, but judges in Europe have taken the inspiration from the courts from Valencia in the 5%, okay, which is a nice example of this. One court starts, okay, I can't really go through these economic expert reports. None of them make sense for me. I estimate the harm. The directive, the law says I can do it. The principle of effectiveness says I can do it. And our system in Spain, procedural system, also allows us to estimate the harm. All the European systems allowed to estimate the harm, okay, or most of them. So they take this approach. This approach is then has been confirmed by the Spanish Supreme Court and has been taken as a solution that we had with the tools that we had right now at that moment in Spain, okay? And even if you go then to the Competition Appeal Tribunal and they have hot tubes and they have all types of discussions and they have the most amazing economists in this part of the world, okay, discussing before the courts for weeks and weeks and weeks, okay, you have hearings that are set up for 8 weeks. Okay, we have hearings in Spain of 20 minutes. Okay, so discussing about exactly the same case and the exact same problem of quantification. And this is still related to what Juan Ignacio has said. Courts, if they can, they have to estimate if they can. Okay, this is a useful tool if you take it in the whole approach. And it's also linked to what Juan Ignacio has said about the collective harm. You have a global harm, okay, that may be then shared between the people that have suffered a harm, okay? So this is a way of seeing this, and this is a way of moving away from, as Juan Ignacio has said, of our individual approach to harm. It's impossible to have an individual approach. In the case of trucks, shows, okay, we have been able to deal with part of the overcharge. But what happens with all the harm caused due to the delayed introduction of the emission reduction systems? There was a huge harm there that we have all suffered this harm, okay? In more pollution, in more costs, whatever. Even there is an amazing study about this of a few economists that have dealt with this question. Who has filed a claim about this? No one. There's no, this is mentioned in some claims, but no one has filed a claim about this. So this is a harm out there that we are also suffering. And we can't have deterrence if we don't deal with these type of questions as well. Because if we have a system only based on, for instance, let's say 5%, then they will take it into account. Instead of increasing the price within the cartel in 10%, they will increase it in 15%, because they know that the price will be, at the end of the day, that they will have to pay, it's 5%. It's very simple. It's the way we dealt several years ago. This is a typical tax law approach. Well, if they impose me a fine, this will be X, no? It will take 4 years. How many interest? Oh, then I take this decision. This is also a wrong message, and we need to deal with this somehow.
I agree absolutely with Julia and Carmen, so absolutely. I think we think very in parallel in some questions, okay. And I want to add some 2 questions about quantification, okay. As Carmen says, quantification is a very national problem at the moment, because there is this first decision that come from Valencia from a judge called Eduardo Pastor. Eduardo Pastor has been my FIDI scholar, and has had his doctorate the last year not this year in 2024, okay, in January 2024. A nice book that I have here, okay, that is no, but it's an important book about private damages. So, and he has tried to use by the first time the possibility to quantificate by the judge in case it was absolutely impossible, so very difficult to arrive at quantification, and it was not clear decision about the parts. You should think in the moment in which this decision arrives. This decision arrives in a moment in which the claimants has a very bad reports about damages, okay, and the defendants were denying any damages zero, okay. So in this position, he had any kind of, the judges, the Spanish judges, has any kind of help to arrive at a decision. And I think the judges are moderate always, and try he has tried to use this possibility for the first time in Spain, and to do in a moderate way. Okay, the question that then has been a time in which has been a debate in the different in between different judges, different appellation courts about the percentages 5, 10, 15, 20. But when the Supreme Court has created his doctrine, has used the 5% as minimum, not as the 5% ever, but the 5% as minimum. Okay, so I think this 5% has a role in Spain, as the 10% in other countries like Czechia, or I remember, I think Hungary perhaps, that have a legal percentage. Okay, they have not only the presumption of damages, but in the case of cartel, but also the presumption of quantified damages, 10%. Okay, so has the same role. Okay, and we should not now, so many years after, we should not fix very much in the 5%. The 5% is only a minimum, and is only plays the role of this legal rules in other systems. Okay, no more. Okay. Second, I want warn about the too sophisticated systems of quantification of damages. I know that the United Kingdom, the experience is very different. In United Kingdom, very high sophisticated systems are debated and are reposed debated, not in 20 minutes, but in several days. That doesn't work in continental procedural systems. And too sophisticated systems create the effect of the black box, okay, and make that the judges reject the conclusions. The more primary systems has the problem that are obviously often flower. So that means they are not necessarily special good. So, but I think this is a problem in all countries. By my experience as teacher of the judges of competition law in different countries, I think that is a common question, a common problem in all continental Europe. And the second or third question, that is, I think, is common for all the continental, not for United Kingdom, but not for continental judges, is they are used to a system of certainty of proof. Okay, not a system of more likely than not scenarios. Okay, and that makes that that is really complicated for the traditional firms, economic firms, very important and competent. Okay, it's very difficult for them arrive to the point. Okay, to obtain a good reception by judges. Okay, I think they should be trained on it. Okay, be trained on it, not on how they should prepare his mathematics, but on how they should present it to the judges. Okay.
Many thanks, Juan Ignacio. Can I just have a follow-up question to Carmen and Julia on this last point which you have articulated so helpfully, because it was exactly something which I wanted to ask as an observer. I imagine you all, that's when we talk about private enforcement, it's usually a fight with big defendants who are capable to engage in various vexatious and meaningful ways, best or very capable economic consultancies, legal law firms, so the best resources, and thus also their defense is not disseminated, is not compartmentalized into many different law firms, it's centralized. And thus, so I wanted to ask you, how does it evolve in terms of their strategies, in terms of defendants' strategies? Do they also mature alongside the claimants, the law firms who representing the claimants? We see they are rapidly developing and maturing. Is defense equally rapid in terms of their development, developing different strategies in terms of maybe delaying or somehow rebutting or raising the standard of proof? Or what are the interesting reflections on this side? Carmen?
Well, I'm not really a practitioner. Maybe Julia's well better positioned than me to answer these. I totally agree that we are going to see, I mean, we already see that together with third-party funding, there's a raise in those claimant-oriented firms. So there's that development. And I think those firms tend also to specialize in those fields. But I think Julia may have more info, more inside info on that than me.
Well, I just want to be polemic, but look at some prejudicial requests that you have before the courts of the European Union about private enforcement, and then maybe you have the answer to your question. Look at the case of Spain. We have a few questions that came from there, like Sumal, Tráficos Manuel Ferrer, Volvo, Nissan, and only the first three that I have quoted are related to trucks, and Nissan it's related to cars. This is a constant issue that you may see, that you called it delaying. Well, I can only see that they raise questions, or the questions have been tried to be raised, and so probably they win time or not, and make the proceedings more or less difficult. And some questions are even about very specific and completely settled things. And some questions are even more interesting. If I look, for instance, in the case, and this is related to digital markets, and this is also because I'm a freak of private international law, look into the case of Apple that was filed by the Dutch court. Okay, it's a question about, can you file an opt-out action in one court, okay, and then apply the process regulation, or should you then file collective actions in each place where Apple has been selling the devices, okay, or the people have been downloading the devices, okay? Or in absence of that, maybe you have to go to the domicile of the company, which is in a place that prohibits by now third-party funding, making it very easy, okay? This is the case of Ireland. And I think that this question is particularly interesting and answers what you are saying. Obviously, it's fully valid, and it's nothing else to add, but this makes the things more complex. On the other hand side, we lawyers, we have the opportunity to write even more and to talk even more, which is also good to have new ideas.
And this is obviously a trend, yeah? So it's just the tip of the iceberg, yeah? What you have illustrated.
It's a trend. And it's a trend. It's like, look, in the 90s and in the beginning of 2000, we had lots of questions related to private international law about jurisdiction. Once this thing was settled in the Netherlands, this was not a discussion anymore. And now they have combined it we see a combination of this issue together with new procedural tools like collective redress, or with other questions like third-party funding or other instruments. Look as well the question of the assignment that we have from Rundholz from Germany, ASK, I think it's called. It's about the assignment model and the German laws. This is a very national question, as well as a question of Nissan. It's a very national question, but at the end of the day, it reaches a European Court of Justice, and then it may come back a few years later, and we see that we try to bring all these new questions, and we will have all for sure questions related to third-party funding. We have them already on a national level, but this will be sooner or later also raised to the European Court of Justice. And if you are an individual small law firm, okay, and you have, for instance, 20 or 30 claims ongoing, or let's say 100 to 200, and then you have suddenly to deal with a proceeding in Luxembourg, then it can be very difficult. Compared, on the other hand side, bring it to what you have said, to a group of coordinated, or more or less coordinated defense strategy teams that try to not only to think about one jurisdiction, but think about it Europe-wide.
I want only say something about this. That, okay, that is your question has I think has a problem. Okay, because in the defense strategy we should take in account not only the economic questions but also the procedural ones. So that means today the procedural tactic of the defendants limited the economic presentations of the consultants. If I say no, there is no damage, zero damages, which is the place for the sophisticated reports of the consultants. I don't know.
There is also, you have mentioned on few occasions the issues related to collective, to funded litigation and collective redress, two different topics. But given that we have shortage of time, if there is some interesting reflections or not, I mean, something important to be said about this, still emergent, still not very well developed mechanisms, which will play higher role in the future of private enforcement in the European Union. And what is the development there? What we hear the criticism about third-party funded litigation. How meaningful and how important this criticism is? Can you proceed these cases without collective redress cases, without third-party funding?
Obviously, I mean, I would say that to me, it's pretty obvious that, you know, third-party funding is essential for collective litigation. And that is one of the points that has been extensively discussed, given that the RAD gives some room for that. And there's, for instance, in Spain, that was one of the points of the discussion, whether that should be granted. It should, but to what extent, what limits, and so on. And that is one of the pressure points in the implementation across Europe that I think is going to be, you know, targeted by lobbies and so on. At least I think, I don't want to be polemic, but I think there's some of that underlying, pretty obviously, because the system cannot work. I mean, I would say something that has already been said, but without opt-out and third-party funding, collective redress, especially for B2C, is not going to work. I think that's pretty obvious. So this is something we will have to see how it evolves. I would say that it is, given the amount of, you know, damages that are out there and not recovered yet, and the room we're discussing for private enforcement as a tool that, you know, both compensation and also that part of deterrence it has always have, right? And also the potential application to other areas different than, you know, antitrust, where there might be other types of damages, right? You know, that is something that, in my opinion, should have been tackled in the RAT, right? It's a shame it wasn't, or it's a lost opportunity, maybe it wasn't, right? But let's see how it evolves. But I think that is an absolute essential point in this story.
Many thanks, Carmen.
I agree with Carmen, absolutely. I have said for years that that is needed the participation of litigation funds in the scenario to re-equilibrate forces between the defendants and the claimants. But I want to point some questions more. Okay, first. I want to do a little history. Sorry, a little history. A little history about we have not an harmonized system of collective claims for competition infringements in Europe, in the European Union. So that is that starts in the first projects of the directive. That starts in a decision, in a political decision of the commissary in charge at the time to separate the regulation of the damages claims and the question of collective action that should be included in a big pack of all kind of collective actions questions. That was the argument, but what was certain is that when arrived this harmonization of collective damages, of collective action claims, of collective claims, it was excluded the claims in competition. So that makes that I be dubious about the which honest was this argumentation. Okay, the fact is that it seems that someone don't want that exist an harmonized system of collective claims for damages claims in cases of competition infringement. Who think you about it? Okay. The question now is that we should overpass this stage, and we should try to convince that is needed this kind of system. And to me today the more important barrier or obstacle is Germany. Germany, the aversion of Germany to the collective claims and to the overall of the funding of the litigation funding. Okay, and so we should ask these who oppose to a system of collective actions opt-out and litigation funding. What do you prefer? That someone want money litigating, or you prefer that the money remains in the budget of the infractors? And this is a question simple. This is a simple question. Okay, decide yourself. And the question of the overshares of the courts is a false question. What makes these overflowed courts is the inexistence of an effective collective claims system. Is that what makes the overflow, not the contrary?
Many thanks, Juan Ignacio. Julia?
There has been always any type of funding and support to actions. If you don't have money, the state gives you the money to litigate. We need equality of arms. This is now, again, the state doesn't have enough resources, and then you have someone else that provides the money. and coming at least in places like Spain, we have now this recent judgment of the European Court of Justice about the participation of investors in law firms. Okay, and this is again another German another German law. We have overcome this discussion in Spain in 2008. The Supreme Court said that you can agree on contingency fees, that you are completely free, particularly for competition law reasons, you're free to set up your fees the way you want. And in our case, at least in Spain, our competition authority, they have imposed fines to bars that have recommended pricing, okay, even within proceedings. And this is also linked to the fact of third-party funding. Third-party funding has always been a solution, particularly in arbitration and in other areas of law. And now it has become more common. And now it is not only more common, the point is that things or actions that never took place before take place. And obviously there is a reaction to this. And the only way to react to this, since you have a clear infringement, you have a clear benefit to one of the infringers at least, no? The only thing where you can discuss is about third-party funding. Mm-hmm. It's the only place where you have a certain scenario where you can play around with new tools. And this is what is exactly what's happening right now. And this is also something that we need to take into account. We have a market already, at least for Spain, that goes from a law firm working fully on contingency fees, or even on the fees that you get from the other side in case you win a case. So the consumer pays €0 to law firms that are earning on an hourly rate basis, invoicing whatever they want to their clients. It's up to the market to decide. And there are also obviously cases of third-party funding. It's up to you. You can decide about it. It's your choice. The point is you need to enshrine this within an opt-out system where you obviously need additional mechanisms because you have an entrusted power as the entity that files a claim and so on. And you need to be very sensitive about this. But I already think that the RAD has already some rules about this, that the European Law Institute is working on that as well with guidelines that they have, that the Dutch courts have already published some rulings and decisions about this type of questions. And we can look also into the experience of the US, whether the courts, they don't go through the third-party funding agreement because it's usually law firms, but they look into all the details and they come to conclusions about, is this proportionate, yes or not? And that's it. And things still work.
Yeah, I just want to add something brief, if you let me be a bit bold, that I've always found a bit striking that we're discussing at all whether we should have third-party funding or not in collective actions. Because if we don't, we all know it doesn't make economic sense to file individual claims, that, damages to disperse, and we need, that system in complex cases like antitrust or other digital market cases, we need, economic resources to bring those cases. So it's to me, it's pretty striking that, and a bit shameless, I would say, that we have on the one side those, big firms that have all the resources, but we are denying the counterpart to find those resources. I mean, I don't think there's a discussion, real, conceptual discussion on that. There shouldn't be, I think, because, we're trying to balance the power of the parties in access to justice. I think it's as simple as that at the end of the day. So yeah, just that brief mention.
Great, many thanks. Let me ask you also a question about the new game in town, the Digital Markets Act, where the scope of obligations is quite generously catalogized by the co-legislators, and the standard of proof is incomparably lower than in ex post competition law cases. And we hear Mark van der Woude saying that it will be a paradise for lawyers. So how do you anticipate the role, how important the role of private enforcement is, it be follow-on or standalone even, and which jurisdiction will take the lead? Juan Ignacio, maybe start with you.
Okay, thank you very much, Oles. Yes, I think that is needed that also the action, the private claims in the case of DMA. Germany has made it possible through a law, but I think I have said, and I will maintain by right, that, and I think Richard Ruiz has said the same in the event. Okay, that with the general rules of or general rules of compensation of damages of present in each state is enough to develop a national system of claims in relation with DMA. Which is the difference? The difference is that in general all the systems has a system of culpability for damages, okay, and there is only exceptions of objectivity, okay. And in the case of if we use the general system, we will face the situation in which we should prove the existence of the dolus or the negligence. So that means the subjective elements of the guilt. But that is different. As focusing in the strict question you have posed me, I think that some systems as Italy and some systems and in other countries in which there is a certain tradition of standalone actions, claims, in the case of the 102 and the equivalent, national equivalent, okay? I think these countries will be probably see easier to use the actions, his national actions, in relation with the infractions of the DMA. And that's not well. This is the subject that I want to develop this summer in my research stay in Copenhagen. But in the case, okay, I think I advanced a little bit, which is more or less my lines, okay, in this thing. I think there is place for the use of the national claims, the national claims in relation with DMA, okay, and that has nothing to do with the exclusivity of the Commission in the application of the DMA. So that is something that don't not hurt in any way, okay, this exclusivity, okay.
Many thanks. Carmen, maybe with you.
Yeah, well, I think there's totally room for the private application for the DMA. I think we're gonna see that in the future, as you've mentioned before. Maybe DMA would be easier to be, you know, applied in private enforcement, even in a standalone, because it's a bit easier obviously after designation, because designation is the monopoly of the Commission. But after that, I think those Article 5, 6, and 7 will be able to sustain a private enforcement of the DMA. I think that's clearly rooted in the text of the DMA, 39, 42. It has been included in the annex as well. So as far as the RAD is concerned, I mean now, and I think I hope we will see that even in standalone proceedings. Yeah.
I think that I agree with Juan Ignacio and Carmen that there is room for private enforcement, and I hope that there will be a lot of private enforcement related to the DMA. The problem will be when you combine it with other causes of action. And you have cases where you have all types of the same conduct that is breaching several rules. And depending on the place where you are and depending on the place where how the RAT has been implemented, you may have an issue with that as well. Look at the case of the Competition Appeal Tribunal. You have now these big cases, competition law related cases that have an aspect of privacy and data protection. They have chosen the path of 102 together with data protection because collective redress is only open to competition law claims in the UK. So they try to crunch everything in one path, which makes a lot of sense in my view. But depending on the place where you will be, it can be treated in one way or another. And this can, at the end of the day, if we have decisions that can happen, not only settlements, that's maybe somehow conflicting. If you look into the Dieselgate litigation, okay, which is a completely different case, but as well as trucks, it's quite advanced. Okay, there you have the breach of environmental laws. You can combine it with unfair competition. You can combine it with contractual breach of contract. You can combine it with pure tort. Okay, so on and so forth. And in this case, you can see you can see different judgments worldwide and settlements worldwide with maybe a similar decision about the potential harm that could have been caused. We all come to the conclusion, yes, this was a wrong conduct, okay, and there was a harm. You have a harm of 100% of the purchase price in the case of the US, and in the case of Spain, you have 500 euros or even less, 200 euros, depending on the place. In Germany, they say something like between 5 and 15% of the purchase price. More is too excessive, and less it's not deterrent. It's against the principle of effectiveness. So we have, at the end of the day, if we look into these examples, okay, where you have different laws that can be the base of your action, and then depending on the procedural path that you have, you choose one or the other, you may have different outcomes. And I do think that that we need to reflect about this, particularly in the area of DMA, because we will have combined issues. What happens in the area of the DMA if, for instance, again, you said it before, users and end users, who is making the discussion? And there you will have a huge issue. What happens in cases that a huge user of a platform has filed a complaint and they have been spending lots of resources over years and years, and then you have a discussion, well, what happened exactly with that potential surcharge, that anti-competitive surcharge that was imposed to you? Were you able to give it to someone else? No? What happens with this other person? And all these questions will raise sooner or later.
I think to connect with what Julia said, I think that is a strategic choice to be made for law firms, right? Taking into account procedural issues, the types of damages, because as we've seen, it's not antitrust is one thing and data protection or other potential areas are different, right? And there is a lot of choices to be made. And I think litigation will, in the next years, will show us a bit where, what the path is going, what is, the most sensible maybe, or at least easier. But again, that will be very much, connected with jurisdictions because of those procedural issues. Because a very interesting point that Julia raised in the conference was what happens if we try and, remember when the damage in the chain, when you want to combine in a vertical and you've got passing on, but you've got that overlap with the, some procedural issues. You raise the point whether, for instance, the Netherlands, you have, end users or consumers below with an opt-out, but you've got professionals above with an opt-in system. And, you have to calculate damages, quantificate that, and there's passing on. All those issues are very, very complex. And I think, the strategics of the law firms will, orient them to the more sensible path, whether that is, as we've seen as Julia was mentioned, as we've seen in the UK, we're going to make those claims, antitrust claims, even if there's some data protection issue, because, we find it's easier that way, right? So, yeah. there's a long way to go. I think we're in the starting moment of, a strong private enforcement. There are lots of issues that are open that makes it a bit uncertain, but also very interesting as well, for us academics. Maybe lawyers get a bit anxious about that, but
Many thanks indeed. I have an extra question. If you still have a few minutes, you have such rich cultural environment with Spanish language having so many jurisdictions. Do you, when we were recommending reading more to students, how much of the percentage is dedicated to English and how much is to Spanish literature and competition law in your daily routine?
In my case, for the students, the most part are Spanish, but also English because in Spain there is a lack of general books about competition law. So that means it's more easy to find an English book or American one that explain the basis of the competition law that found one actualized in Spanish. But in the case of when you arrive about particular questions, Spain has a very rich bibliography of competition law with many books, many articles, and decades of work of the very competent people that in general is not in the international debate because they publish in Spanish. And this linguistic barrier makes that you don't know what we are doing because we know very well what you are doing. So that means, and we cite what you do, okay? And I think that the new tools, translation tools, and the new systems to use. I remember that someone says me that the UIPO, all the documents of the UIPO was translated by DeepL, and they only make the revision after. Okay, they only make the revision after, and that make very lower the price of the translations. Okay, I think the future is that. We are in next years. I think these linguistic barriers will be weaker first, and then will disappear, and that will be very good for a mutual comprehension. I hope that I arrive in activity at this time, okay? But I am sure that Carmen and Julia will be, and the people of the because Carmen and Julia wrote we wrote in English, and we have published in English, and we have published in German in the case of Julia, and so, and Carmen also, and the question, but it's a minimum part of his work. It's a minimum part of his work. The most part of his work is no in the international debate. And if you think that in this meeting, in this seminar, we have said something interesting, perhaps you are losing something.
Many thanks for answer, Carmen.
Well, on my side, I work a lot in English, also partly because I've been teaching competition law in English for many, many years now. At the law school, we have some courses taught in English, and so I specialize on that. And well, to have a positive, insight on that, I do see that young students, they master English, much better than previously. So I always use materials both in Spanish, but in those courses in English, obviously, because that's the language of the course. And I think some of them, they're also write pretty decent English. So I think, yeah, as Juan Ignacio was saying, so language still may be a barrier for some, but it's becoming less and less a barrier. And yeah, it's a pity that some of us, well, some of our colleagues don't publish in English as much, but I think that's going to change with new generations. So yeah, it doesn't bother me at all.
Many thanks, Julia.
Well, the academic work in English and Spanish, both, as well as some things in German. I do think that, as Juan Ignacio has said, we have better tools right now that make it very easy and helpful. And if I remember the way I started working and the way I started in the academia, going to Hamburg, for instance, to the Max Planck Institute and making thousands of copies, and where we are right now, this has changed a lot. And the way it works on the academic side, and also, as well as Carmen has said, we have now students, they talk very good English, very good, and this is very nice. We have mixed courses. I'm very lucky. I have a course in the winter where we usually have at least 8 to 10 nationalities. And it's about comparative law. It's international trade law, and it's very nice. Because we keep comparing systems, and the discussion, it's very enriching. If you start discussing about this with a Swedish student, together with someone from the US and with someone from a Latin system, like civil law system, like Spain or France or Italy, and the result, it's very enriching, I think, for all, at least for me as a teacher. I really like it a lot. And this is only possible due to the fact that we all have a minimum common denominator, in this case, English. And I hope that this will be the future scenarios, particularly taking into account that students are moving more and more around Europe or other places out of Europe, thankfully. And this will be the common denominator in the next decades, particularly also for once you start working. You won't still be working in a place like Bilbao here, where I'm sitting right now. It's going to be very international, and you will be moving all around.
Many thanks indeed for this fascinating, very informative conversation. I wanted, as a tradition requires us to do, to finish it with inviting you maybe to provide just final reflections, and most importantly, recommendation to students, those who are about to graduate, what may be some specific skills which they have to practice, them, or things which they have to avoid, something which can be seen as kind of pastoral, collegial hint to those who will be shaping and calibrating the private enforcement in the following decades. So, Juan Ignacio, please.
Oh, well, as a resume of our conversation, perhaps say that we are in a transition time. We are, as Carmen says, in the start of a new era, and I think in the next 4 years, many things that we are studying now will be more clear. So, and perhaps in 10. It will be a better situation for private enforcement. Okay, that's clear. I think one of the questions that is very important is also change of perspective between consumers and final users. So that means I think we should focus the question in final users, because final users, as investors, as bank customers, as policy takers, okay, are the people that should be protect and use and see as a collective. The problem is that we have a long tradition of division between consumer and business. And this long tradition has only some exception in the case of Germany, in which it was an approximation between a small undertaker and consumers for some questions. Okay, and we have this tradition, and this tradition is I think in the case of digital markets is terrible, because in the case of digital market, the asymmetries between the gatekeepers and the professional users, but also the final users, okay, are absolutely big. Okay, so it should be seen as a category. Which is the problem? That we have all our procedural national laws constructed over the concept of consumer. So in the next years, we should focus in this question, I think, and try to change this optic in relation overall in relation of damage claims in digital markets. In the case, in particular, in this case, how the students. we are in a world that changes day by day. Legal tech, training in legal tech, training in AI, in artificial intelligence. So these two questions are essential for all kind of development, but are essential for the new future. So if you see the actuality, if you see what happens now, and you see who are the big man in war at the moment, or will be after the 20th of January, you should think that legal tech and AI are two questions that a lawyer should know well, as before was the economy. Okay, as before was the economy. This is my tip. Okay.
My final thoughts, as I would, I think I've pointed them in my previous comment, so that would be that. And for students, I think I will have just a couple of general remarks. Stay curious about the things that are happening around you, both in the practice, in reality. Check, social media. Well, I was going to read newspapers. That'd be, naive on my side probably, but be aware of what's happening in reality, and also be curious about what has been published, and the different lines of thoughts. And as a complement to that, be critical. I mean, there are many controversial issues, right? And you have to stay a bit critical on the things you read, and just try to internalize and contrast them with the values that you think are important. So that would be, I know it's general, but more than any specific thing, I think that is like a mindset in general for everybody, I would say, if you want to go in academia, of course, but in general, be curious, be critical, and the rest will follow.
Well, I would like to add, think out of the box. First thing, the more the better, and also look into history. We have been talking for 1 hour and a half by now about digital markets, and Juan Ignacio has raised the problem of AI. Well, the problem or the potential aspects of AI, which will, of course, have a lot of competition law issues, by the way, even without understanding it. So we need to understand it, and then we will see what's going on there. As Juan Ignacio has pointed out, not only for practical purposes to use it for your legal profession, but also to understand what will happen in the economy in the future. But go back to history. All these discussions that we have right now in the area of digital markets, they are old, many of them. Tim Wu points this out in his works, and there are several publications about this. It's about the power of companies and keeping power of companies to obtain a higher benefit that they would obtain in fair conditions and in market competitive conditions. It's about this, and we have been discussing about this already for quite long. And if you look into the answer that we are seeing in some places of the world, like the US, about questions linked to digital markets, they are going back to the basics. So think out of the box and go back to the basics, where you will find a lot of information. It's quite interesting. I'm preparing right now a writ, and I read the opinion of another party, okay? And this other party is now saying the opposite that they said 10 years ago, although they tried to defend exactly the same issue. And I think they didn't look into what happened 10 years ago. Time passes very fast. And now, yeah, it's quite surprising that they are defending the opposite. Although they try to, at the end of the day, they are trying to obtain the same, they are trying to reach the same objective, which is nice. And this means that you looked into the last 3 years, but you may have not looked into what happened 10 years ago, which is quite important sometimes.
Amazing. Thank you very much. Julia Suderow Rodriguez, Juan Ignacio Ruiz Peris, Carmen Estevan de Quesada. Thank you very much indeed for this conversation. It was a pleasure to see you.
Thank you.
Thank you.
Thank you very much.